Yes, for school.
Your Lordships, if I may, I appear on behalf of the local authority appellant in this matter. The parties and present here in court today are the social workers sitting behind me, Ms Kelly Jeffs and Ms Day. Sitting to my right I have Ms Gray, who's representing the mother. Representing the guardian we have Mr Crawley, and we also have the paralegal of the instructing solicitor, the guardian present in court, Ms Peck.
That's very helpful, thank you. May I just emphasise one thing before you begin, really for the benefit of everyone in the court, including the members of this court. The proceedings are being live streamed, which is important in the interests of open justice, but it does underline the need to be especially careful that we don't inadvertently refer to the children in this case, or any members of their families, by name. Thank you.
Yes, I understand that, Your Lordship. This matter pertains to two children. The eldest, who is currently 8 years and 6 months, and was 8 years and 3 months at the time of the local authority's final hearing resulting from the application. The youngest, who is now 2 years and 10 months, but was 2 years and 7 months at the time of the final hearing. This court ought to have before them skeletons on behalf of the local authority, the mother and the guardian. I appeared in the court below, as did counsel for the guardian. My learned friend for the mother did not, but I understand is fully briefed and instructed in this matter. I wonder if it might assist if I outline the structure that I intend to adopt for my submissions.
Yes, thank you.
Firstly, I intend to begin with a very simple and very brief background to the matter, the case law that is in contention and why, and then the grounds that I have pleaded within my skeleton, but I also intend to develop those and answer those points raised by my learned friend on behalf of the mother, and then any particular issues that pertain and arise out of updates that the local authority have provided in relation to both of the children. Ground one, I intend to address the balancing exercise that was undertaken by the lower court, and also under ground one, whether sufficiently addressed were the advantages of foster care versus the disadvantages, and whether particular an overarching emphasis was given to sibling contact in this place, which ended up displacing the other important factors within the matter. On ground two, I was intending to address how the eldest child's wishes had been factored into the decision regarding the younger child, with the net result that the youngest child in the local authority submission's welfare had become contingent amongst the older, with an update to follow. So by means of brief background to the matter, this was an application that was made on the 3rd of March 2022. Judgment was provided on the 8th of December 2022. A clarification was received from the judge on the 3rd of January 2023, and I've set that out within my skeleton argument as to what the queries were that were raised with the learned judge. Those included why a full list of options outlined, indeed by the judge himself, had not been fully considered, namely his own proposition that there could be care orders without placement orders made, and indeed contact orders. What consideration had been given of the impact on the youngest if a move from her current foster placement was necessitated, and how the youngest child's relationship with the older child had been considered in isolation from the older child's relationship with the younger. The reply received on the 3rd of January is set out also within my skeleton, and to put it briefly, it stated that of overarching importance within this case was the contact between the siblings, the hope that the younger could remain with her current foster carers long term, the accepted impact on the younger of the loss of the older sibling, that was likely to be less, but no further comment was offered on that particular point. And as a result, an application for appeal was made on the 23rd of January 2023. The case law that is present within the authority bundle, and I do apologise if that was not received earlier. I understand that a number of versions of that bundle have been carried to court this morning, but I understand that you do have those bundles before you, and I'm very grateful to the efforts that have been made on that behalf.
Yes, and we did have them in electronic form as well.
I'm grateful, Your Lordship. The case law that is present within that bundle includes re-BS, and also in the matter of HW. That's referred to at B29 paragraph 3 of my learned friend's skeleton argument. And a particular quotation is relied upon, and that's it, the task of the court is to evaluate all options in a global, holistic and multifaceted way, with each option weighed against its internal positives and negatives and then compared side by side with the other options presented. It's not common ground between the mother and the local authority that that was adequately carried out by the learned judge in the court below. The mother asserts that it was, the local authority asserts that it wasn't, and in fact the local authority considers that of the list presented to the court, they were not in fact fully explored as a full list of options, that a full comparison was not carried out, and despite the court having presented a number of options, in fact the local authority had not sought as such as care orders without placement orders. Those were not fully elucidated and considered within the learned judge's judgment. Re-W is additionally a case present within the bundle of authorities.
But that doesn't seem to be in the electronic version.
It may be that that hasn't made its way into the bundle.
Let's have a look.
Re-W.
Re-W.
It's not in the hard copy either.
Perhaps I would.
What's the reference?
It's 2016 EWCA CID 793.
Sorry, EWCA Civ.
Civ 793.
793. Well, I can get that up, and my lord may be able to, but my lady won't.
I do apologise, Your Lordships.
Is it going to be important for your submission?
I only glancingly refer to it.
Well, we may be able to manage for the time being at least.
I'm grateful, Your Lordship. Perhaps by reference I can refer to my learned friend's arguments in relation to that case law. The argument developed by my learned friend for the mother is that the older child's view are of importance in determining the welfare of the younger. That is agreed by the local authority. Although there is a suggestion that the local authority assert within their skeleton argument and that those submissions are tantamount to discounting the older child's views. That's not accepted by the local authority. It's agreed that the older child's views are of course of relevance, but that they form part of the welfare analysis and not the whole of the welfare analysis.
Yes, I had not understood the difference between the two of you in your skeleton arguments to be any different from what you've just said.
Thank you, I'm grateful, Your Lordships. I'll move on. In relation to Re-B, that's included due to the exploration of key differences between adoption and long-term foster care. My learned friend on behalf of the mother asserts that the key differences between those two placements were more than adequately considered and factored in. However, the local authority invites the court to find that any consideration of the risks inherent in long-term foster care was slight, to say the least, and were not tailored, in fact, to the younger child in question, who is going to be subject to long-term foster care if these orders remain for the next 16 years. Perhaps if I might turn to my submissions on the grounds of appeal, beginning firstly with that balancing exercise, and it's the local authority's contention that that was not adequately carried out. The opening arguments in relation to that are set out at B35, paragraph 26 of my skeleton argument, and also at B35, paragraph 27 of the judgment, apologies, wherein the judge stated that it would be usual for an adopted child to forget their birth family. The local authority suggests that this would indeed often be the case, and particularly so for a child of the youngest sibling's age. However, within the judgment, this was balanced against the weight placed on the relationship by the older sibling, with the lower court outlining a remarkable analysis of her fears that the older child had elucidated to the court.
Forgive me for the interruption. Which paragraph of the judgment are you now talking about?
This would be paragraph 8, A33.
What do you say about the first sentence of paragraph 9, where it's emphasised, the Guardian rightly reminds me that it is but one consideration?
The local authority's contention would be that although reference is made to the correct test within this judgment, and the reference is made to the fact that this can only be part of a global holistic analysis, in fact, the analysis itself doesn't fully consider all of the factors that need to be featured and factored in, and as a result, the lower court fell into error in allowing too great an emphasis to be placed on those factors, despite the fact that the lower court had reminded themselves of the correct test.
For my part, I agree with you that it's quite striking what he says in paragraph 8. But what he says in paragraph 9, in addition to the first sentence, to which my Lord has referred, is the second sentence. There was evidence before him from two professionals that the need for ongoing sibling contact was essential for the younger child. So, in a sense, what he says in paragraph 8, although it is striking, as you say, is not really, is it, a key part of his reasoning?
The local authority's view is that essentially overarching, and I think it's referred to within the judgment as an overarching consideration, sibling contact allowed, and I've referred to this within my skeleton argument, the fulcrum when balancing all of the factors together to be placed too closely towards sibling contact, and as a result that displaced all other factors that ought to have been.
But if there was evidence before him, as there obviously was, from these two professional witnesses, I'm not naming them deliberately, that sibling contact would be essential. It's not surprising it featured as at least a major factor in his considerations.
Indeed, Your Lordship. The local authority had grappled with that within a number of the assessments that they provided towards the court and within their oral evidence. And the conclusion that they laid before the court was that although contact was essential and needed to be considered, that would feature in any placement search for adoptive parents potentially for the youngest, and that they would be specifically searching for an adoptive placement where contact would be allowed. They would be specifically searching for a type of carer that was open to that contact and was willing to provide those assurances of contact, and that was a means of managing contact between the siblings. And it certainly wasn't a closed door that contact would never take place following the making of placement orders. And the local authority had been very clear about that, that it would feature in any placement search, and if those adopters present or weren't achievable, then she simply wouldn't be placed for adoption. That had been frontline and centre of the local authority's evidence, and it's clear that that can be seen from the very first sibling assessment that's undertaken in the matter, then following with the addendum sibling assessment, and indeed in the oral evidence that was presented to the lower court.
Again, forgive me just coming back to you on that point. As I read the judgment, what the judge was concerned about that was that the level of contact which could be expected if the child was adopted would not be on the scale that she required.
Again, the local authority...
Just so I'm clear what I'm saying with that. In other words, it would be typically contact, if there is contact post-adoption, it may either be letterbox contact or indirect contact of some other form. Or if there is face-to-face contact, on a very limited scale, perhaps once or twice a year. And the judge felt that wasn't going to be sufficient.
I understand entirely, Your Lordship, that point. The local authority were grappling with a very complex case in relation to sibling contact. They were aware that even if the youngest child were to be placed in long-term fostering and the older child to be placed within their paternal family, nevertheless there was still going to be great hurdles to overcome in relation to contact. they would potentially mean that any contact was going to be limited in any event. That stems partly from the fact that the oldest child was going to live over 200 miles away, and therefore any contact was going to be likely to be difficult. No evidence, unfortunately, was before the court as to whether this particular current foster carer would be able to facilitate contact over those distances and to take the younger child to meet her elder sibling, or indeed vice versa. And in fact, the distances travelled that would need to be travelled were already a factor that had provided some consternation to the court, as the father himself had not attended the hearing. He'd chosen to attend remotely, indeed on that basis, because of the distance that he would need to travel to attend court. And that was noted within the oral evidence that was provided to the court, that these were obviously distances that would be difficult if contact was going to occur. Additionally, the current foster care of the younger child had not been approved for long-term foster care, so there was simply no evidence of what might happen in the future, whether a future foster parent would be able to facilitate those lengthy journeys up to where the older child is now residing, or indeed whether that would happen in the contrary way. And in fact, the judgment referred to creative thinking, but it's the local authorities' view that simply that creative thinking wasn't thinking that would have been achievable for the local authority, because there are too many unknowns, most particularly the difficulty of finding a foster carer who would be able to facilitate that distance to travel and those contacts over, as had been stipulated by the judge, a number of contacts per year. And the view of the local authority was that contact was likely to be difficult in any event, whether in foster care or in an adoptive placement. And in fact, the level of contact achievable was likely to be similar whether she was in foster care or indeed in an adoptive placement.
I understand that, but if a child is adopted, as I understand it, normally they would not know about their birth parents. Whereas here, it was going to lead to a very unusual situation, wasn't it? At least the judge thought so, I think, that because there was going to be contact with her older sibling, it's inevitable that she would come to learn during the course of her life, during her childhood, not just in adulthood, but during her childhood, she would come to learn about her birth mother. That would be a very unusual situation, wouldn't it, in an adoption?
It would indeed, Your Lordship, and that had featured in the local authority's analysis of who they would approach to be an adoptive foster placement for this child.
Sorry, adoptive or foster? You said adoptive foster.
Adoptive.
Adoptive.
I apologise, Your Lordship. An adoptive placement for this child. The family finder gave evidence in the matter and was pressed on that matter as to whether this would be likely to be something that would be facilitated in such a search. And he said although it would limit the pool of adopters, nevertheless it was a factor that would be featured in, and nevertheless the local authority took the view that it was of such concern to all of the professionals involved that it would feature within any search for an adoptive placement for the younger child. So although it was acknowledged it would be an unusual situation, the fact was that Matilda was, I do apologise, the younger child was already of such an age that she knew who her family were, she knew who her sibling was and her older siblings were, and therefore that would she would already have that knowledge. But nevertheless, the fact that she would be in long-term foster care for the length of her time displaced those considerations, because her developmental needs were such that she would need to be in a placement potentially on her own singly, with attuned carers who would be able to provide stability, with no hint that that was likely to fall through due to a move to another foster placement, and that those adoptive parents would have the parental responsibility to make the changes and the needs and the decisions that the youngest child would need, and that would be of developing importance as her developmental needs became more obvious as she grew older, and they were already coming to the fore in the foster placement. Those developmental needs had included the fact that when she entered the foster placement, she was not yet answering to her own name, and in fact the oral evidence provided was that she responded to whistles from her older sibling. It was the fact that she did not seek out adult care or adult affection. All of her needs were settled upon her older sister, who had been providing that care when placed at home.
Could I just take a step back, just following on my Lord's point. So the evidence was that it would be, is this right? That it would be that if it was required, that if these child's needs were, first of all, particular needs because of concerns about developmental, that would reduce the pool of prospective adopters. That pool would be reduced further if it was a requirement for there to be face-to-face contact with a sibling. And further still, if, as my Lord reminds us, it was known as it would have to be that the older child was having face-to-face contact with the mother. So in effect, it would not be a guaranteed, that dreadful phrase, closed adoption. So that would, all those factors would reduce the pool of possible adopters for this child. Is that right?
Yes, that's indeed correct, Your Lordship, and the seal would be wouldn't be present between the birth family and any adoptive placement for the youngest child, by dint of the fact that she would be having contact with her older sibling, who was still having contact with her mother, and so therefore there would be that linkage between the youngest child and the birth family, which would be unavoidable, and that had featured within the analysis.
And the judge took those factors. Do you say the judge was wrong to take those factors into account, or how do you put it?
It's not, Your Lordship, that the local authority take the view that he was wrong to take those factors into account. It's the weight that was placed upon those particular factors. The local authority would place a greater degree of weight upon the youngest child's developmental needs, and particularly the level of statutory intervention that she would be subject to for the rest of their minority. It's the contention of the mother, and indeed is present within the judgment of the lower court, that in fact the weight needed to rest upon maintaining a sibling contact, and that it simply wasn't workable if the seal was broken between birth family and adoptive placement.
Once we get to arguments about weight, of course, in this court, then an appellant faces the difficulty that we're not the trial judge, and case law makes it clear that we must be very slow to interfere with the attribution of weight to particular factors in this sort of judgment. How do you get around that difficulty?
That difficulty is circumvented by the local authority in my submission by the fact that the judgment provided by the lower court was so single factorial, and the fact that a balancing act exercise between those numerous factors, although referred to, was only slightingly referred to, and there simply wasn't the adequate reasoning in consideration of those factors that would weigh against.
Yeah, sorry, I don't want to interrupt you if you haven't finished, but look, I think that your criticism of the judgment, as I understand it, is not simply an inadequacy reasoning point. I think you do say, is this right? You do say to this court that at the end of the day, the balance struck by the judge was just wrong. And this is where your fulcrum point comes in, I think, that it's one thing to do a balance where everything is, as it were, weighed equally. There's no sort of starting point about where the balance is going to end up. But I think you say, not necessarily saying I agree with you, but I think I understand the submission, is that the judge has fallen into error here, because he adopted the sibling contact consideration as being so important that it effectively amounted to the fulcrum. And so the balance is going to be struck wrongly, because, for example, you are not then able to give adequate weight to very important considerations like the younger child's developmental needs. And you've given us an example of the difficulties that she was experiencing if she isn't even answering to her name, for example.
Indeed, Your Lordship, and Your Lordship has expressed it very clearly. That is indeed the argument that the local authority was seeking to make to this court. Additionally, if I can add to that, it was the fact that by giving such an overweening importance to the sibling relationship, the fact was that in any case where there was an important sibling relationship, that degree of analysis would have produced exactly the same result, which would have been that the child could not be placed for adoption, and that surely cannot be the case. The law has to adapt itself to individual cases, and it cannot be the case that the court begins from the starting point that if sibling contact is going to be given such a degree of importance, that adoption simply cannot be the result that a court reaches. The reason that the court was using and provided within their judgment essentially boiled down to a conclusion that given the level of sibling relationship, adoption simply couldn't occur. And in my submission, that would have created a test that would have meant that in any case before the court, an important sibling relationship would displace any consideration of adoption.
I hear how you put it. It's an interesting way to put it. But you could say, in fact, the right way is to look at it at a slightly different angle, which is that you had to persuade the judge that nothing else will do. And was it your case that only adoption would meet this child's needs, and therefore the judge's decision was wrong?
The local authority indeed presented that care plan to the court, and they based that on the youngest child's developmental needs, as I've already outlined to the court. They based that on the need for any carer of the youngest child to provide stability and attuned care, reference being made to that child being placed singly. It was a very specific set of circumstances within an adoptive placement that the local authority was looking for. It wasn't a pro forma or a one-size-fits-all adoptive placement that they were searching for. It was a very specific set of factors that they would have made, put in any adoptive search, and there was the acknowledgement before the court that of necessity that would limit the people who would be available to care for the youngest. However, the local authority's overarching consideration was the welfare of the youngest child, and that welfare, in their view, fell closer to a need to making sure that her developmental needs were met, notwithstanding the importance that they placed upon sibling contact.
Thank you. Now the court has had a number of questions for you, but you don't want to interrupt the structure of your submission, so you must present the appeal as you see fit.
Thank you, Your Lordship. I'm very grateful. A number of the points that I wish to raise have already been covered within the questions raised by Your Lordship and Your Lordships and Ladyship. But however, I will continue in the vein that I had adopted. I was dealing with the issue of the balancing exercise. I had made reference to the eldest's fears drowning out, to some extent, any other argument, and that was indeed a phrase adopted within the lower court's judgment. That's at paragraph 24A37, and the fact that it drowned out, in fact, the eldest child's wish to return to her mother. And the argument in the local authority's submission was that the eldest wish for both children to remain together had formed an imperative that determined that sibling contact should take place at all costs, even at the cost of the younger having a stable care and an adoptive placement. The learned judge referred to an imperative need not to allow a system of Hobson's choice to build up. Again, that's referred to within the judgment. However, in the local authority submission, that's unfortunately exactly what happened in the analysis that followed. 7 options were presented. There are paragraphs 2 to 9 of the judgment at A31 to 33. 6 were almost immediately discounted. The local authority invited the court to consider that those 6 were discounted purely on the basis of the sibling relationship, and most particularly on the basis of the eldest child's strongly expressed views on the matter. And the suggestion was also made that if the youngest child remained in foster care, then the mother might potentially be able and agreeable to caring in the future for the youngest child and indeed the older child. However, there was no indication within the evidence of any likelihood as to this. The likelihood was that even if such a change were made by the mother, it would not be of a sufficient degree for a number of years. And the assumption that the youngest could simply remain in stasis in the interim in foster care, despite any lack of evidence before the court as to timescales for change, meant in the local authority submission that this was an unfair weight that geared towards a foster placement for the younger rather than adoptive placement. With regard to the advantages of foster care versus the disadvantages of foster care, there are clear detriments, as I set out within my skeleton and are present within REV in remaining in foster care. It's the local authority's submission that they were not considered fully, and in fact the inverse was presented. The positives of remaining in foster care were presented within the judgment, and those included sibling contact and the potential for reparative parenting, and that's at paragraph 30 to 32 of the learned judge's judgment at A39. However, the converse of that must also be true, that the youngest would have lacked stability going forward for the rest of her minority. She would be subject to statutory intervention. Her developmental needs would potentially go unmet, as there was no guarantee that she would be placed within a foster care placement where the foster carer would be able to provide her with the one-on-one care that the various sibling assessments had surmised that she would need. There would be no guarantees as to frequent contact. As I've already outlined, no evidence had been presented to the court, and there would be the potential detriment to emotional and psychological health for the youngest child as a result of all of the above. And it was not considered by the local authority that any of those detrimental features were referred to in any great depth in the judgment, and instead there was a singular focus on making a foster placement work in order to provide a level of sibling contact.
I noticed you've used the word fully 5 minutes ago. Now you said in any depth. Do you accept those factors were referred to?
Yes, Your Lordship, of course, they were referred to, but it's the level of analysis that underpins those references.
Thank you.
This really comes back to your fundamental submission, that it's not simply a question of ticking boxes, that the ultimate outcome must be not wrong. And you do invite this court to say that the ultimate outcome was wrong. Is that right?
Indeed, Your Lordship, that's entirely correct. And as I've already outlined, there was no consideration within the learned judge's judgment as to how contact would be practically managed, even in a foster placement. And as I've set out within my arguments pertaining to the fulcrum of B17, that allowed the fulcrum to be placed too heavily upon prioritising sibling contact. And perhaps if I develop my submissions in relation to sibling contact. At B31, my learned friend invites the court to consider the magnetic importance of the sibling relationship in this matter, and refers particularly to the first sibling assessment, in which separation is considered as likely to cause trauma. And a particular particular issue was that of future sibling contact and whether that would be practicable. And there were particular difficulties acknowledged by the local authority, as have already been referred to, particularly in light of the limitation of the adoptive pool. However, the suggestion that remaining in foster care would afford greater opportunities for contact was simply not something that could be evidenced to the court. And as I've already referred to, there were substantial difficulties with contact. Those were practical difficulties, including the work commitments of the father, the length of travel journey needed between any contact, who would be facilitating that contact, who would attend that contact in order to supervise it, even if it were a grandparent, as would be required. There was simply no consideration within the judgment as to how those practicalities would work, and the local authority was simply invited to engage in creative thinking when in fact they had perhaps been presented with an impossible task. The difficulty was that this falls again to my central point that sibling contact was being allowed to trump all considerations. And it automatically followed that if sibling contact compromised in any way an adoption, then it would not be followed, then it would not be ordered by the learned judge. That appears to be in line with my learned friend's understanding of the judge's rationale at paragraph 19 to 20 of her skeleton, and that's at B33, wherein the judge stated on the 3rd of January the judge added that no adoption order would be likely to provide the level of contact required. The local authority contends that such a rubric in the cases where sibling relationships are of such high importance would automatically produce a result of disallowing placement orders and separation of siblings, and as I've already outlined, that simply cannot be the case.
I think in that context you place due particular emphasis on the beginning of paragraph 32 of the judgment.
Indeed, Your Lordship.
Can I just ask you about that, because I just want to be clear I've understood your submission correctly. I understand what the judge is saying there, that an adoptive placement is likely to be found. It's likely to meet all of her needs, except her need to be in touch with her sister, regarded as essential by the mother, local authority and guardian alike. That's a point my Lord has drawn to your attention. So there, as I understand him, the judge is saying what would be positive about an adoptive placement, and then there's this very important negative feature. But can you just help me with this? Where in the judgment do we find the judge setting out the negatives of a long-term foster care arrangement?
That's indeed the local authority's submission, Your Lordship, that they are simply not present. There's no reference in any tailored sense to what it would mean for the youngest child if she were to remain in long-term fostering, with particular reference to her developmental needs. And although there is a glancing reference to the fact that a foster care placement might be able to provide reparative parenting, that is in fact in contrast to the evidence provided by the guardian, which had been that reparative parenting ought to be something that was offered within an adoptive placement if it were to take hold and to take proper effect, and that would of course form part of the local authority's search for any prospective adopters.
You say, I think you said glancing reference, I think that was the phrase you used. You're referring, are you, to what he said at paragraph 36 about adoption providing a forever family in a way that long-term fostering would not? That's a sort of shorthand, isn't it, for a reference to the fact that long-term fostering does not provide permanency and security in the way that's what you have in mind.
Indeed.
Glancing.
And when reference is made to the submissions of the local authority and the evidence of the social worker, where they had considered the difficulties in long-term fostering for the youngest child, that was referred to negatively by the judge as simply having been perhaps a pro forma argument.
Paragraph 31.
Indeed.
the usual ones advanced.
Indeed.
You think that was...
Indeed, Your Lordship.
You
indeed.
suggest that's a slightly dismissive way of putting it, do you?
Indeed, I would make
Yes.
that suggestion.
But
Yes,
they were the usual ones. And he's taken them into account, isn't he?
In my submission, he's not.
So you say that the fact that he referred to them in that way, is what you're saying, suggests that he was not taking them
Indeed, Your Lordship.
sufficiently, not seriously, but not focusing on them with regard to the specifics of this case. Is that right?
Indeed, Your Lordship. They may well be arguments which are encountered time and time again in court, and submissions that Your Lordships and, of course, the learned judge have heard time and time again. But the reason for that is because they have a weight behind them that is built upon an evidence base, and that was why they were advanced by the local authority.
Yes, it's one thing to say, as he does at paragraph 36, that long-term fostering would not be as good as adoption. Okay. That's one point. But I think you're making, at least additionally, you're making a different point, are you? That long-term fostering can have detrimental consequences, particularly on the development of a child such as this. Have I understood that correctly?
Yes, that is.
And this is not a purely rhetorical question, it's a genuine question. I'm looking for help on where in the judgment the judge asks himself that question. Is the order that I'm about to make going to have any detrimental consequences on the needs of this child? And I think you say it's not there, and that's the problem. The other side may say it is there, no doubt we'll be given assistance on that in due course. Is that fair?
Yes, that is a fair outline of my argument, Your Lordship, that it simply wasn't factored in, and it's not present within the judgment.
Right, where are we going next?
If I may, if I turn to ground 2, which was the implementation of the welfare tax.
Could I just ask another question before we move to ground 2, rising out of that? I hope that won't disrupt you too much. What evidence did he have about the disadvantages of fostering in this case? You referred to some specifics which you say weren't included in the judgment. Where was the evidence about that? I mean, we don't need to go through it line by line, but have you got could you point out where it is in the bundle?
Of course,
if required.
Yes, there had been a careful analysis in my submission undertaken by the local authority within the addendum sibling assessment,
right.
Where they had changed their views in relation to separation of the siblings. Initially, the local authority had taken the view that these siblings ought not to be separated, but when it became evident that there was a placement within the family open to the older, that had been consideration that they had needed to grapple with. And in fact, the intention had always been for the local authority to grapple with, as they'd undertaken a number of assessments of family members post the first sibling assessment. So that was always a consideration that the local authority knew needed to be covered.
I'm really asking for help as to where was the evidence about the disadvantages of fostering in this case, the specifics, as opposed to the usual, what the judge referred to as the usual ones. But was there evidence about the specific disadvantages in this case?
In my
fostering?
Your Lordship, yes, there was. Within the addendum sibling assessment, careful thought had been given to the youngest child and what it would mean for her if she were to remain in long-term fostering, with particular reference to statutory intervention.
So this is the document at A16, tab 16.
Yes, it may take you some time to find the exact page reference.
That's where we'll find what you're talking about.
Additionally, also, Your Lordship, there is the child permanence record, where particularly in consideration of the youngest child, reference had been made to her particular needs, her developmental needs, and what that might mean in terms of any future placement. And why
is that tab 22?
I have it. The the CPR report, I have it, particular reference I've made to A234. Yes, it will be. Yes.
Okay.
234.
234. Right. That seems to be a document which begins local authority social work evidence template, final statement.
I think my lord is right. It's tab 22. That's the permanence report. That's it.
I apologise, Your Lordship. I'm grateful to my own friend. It's at page A328.
That's it. That's right.
Yeah. Yes, that's the child permanence report. Yeah. Thank you.
So, just looking at the first document you referred us to, the addendum sibling assessment. I note, for example, at A254, paragraph 3.4, the author refers to research has shown that long-term foster care can have a detrimental effect on the mental and emotional well-being of children, etc. Is that what you're referring to?
Yes, those are particular references to statutory intervention. Yeah. There is further consideration given to what it would mean to the youngest child,
Yes.
let's say.
Okay. Well, that's obviously what we're specifically looking at, because it's the specifics of the disadvantages of this case. Indeed. That you were saying is not in the judgment.
Indeed, and particular reference to the youngest is made at A257 within the support needs for carers.
Right. Is it where specifically interests me? What paragraph in particular?
Apologies, Your Lordship, that's not what I intended to refer to.
Yeah, we can come back to it.
7.3 it appears to refer both to foster carers and adoptive carers. On page 257.
There's perhaps a better reference in part 6 above, which is at A256. That's the level of therapeutic intervention both children might need. And within the final evidence of the social worker, the particular needs of the youngest were outlined in terms of her need to potentially be placed on her own.
I mean, I don't want to generalise, but that's why I'm asking about the specifics, because it's sometimes said that a child who has particular developmental needs will get more support in fostering than an adoption because of the way support services are structured. But I'm putting a general point to you, and I'm interested to know what the judge knew about the specifics, what the evidence was about the specifics. Yeah.
There was limited evidence on the specifics that could be provided by, in particular, this foster carer. And Your Lordship and Ladyship will have seen from the judgment of the lower court that particular reference was made to this foster carer being a very good and excellent foster carer, and the hope being that the youngest could remain in her care. Unfortunately, that's proved not to be the case. But there was very limited evidence as to what particular targeted support she could provide over and above simply being an excellent foster carer, which is of course of high importance, but it wasn't necessarily the level of therapeutic intervention that the youngest child might need, and that's why reference had been made to the youngest needing one-to-one care and attention, to being a single child within a placement. Any foster placement, if she were to remain in long-term foster care, would have to be for her singly, and the difficulties of finding a placement that would allow that.
The moment, Ms. Gould, the impression I'm getting is that this element, the developmental needs of the child, didn't point clearly one way or the other. What the child needed, I think it's 6.3, child needs to be supported by her primary carers through the provision of a safe and nurturing environment where she is supported to express her emotions. Ultimately, that's the quality of the placement, whatever label it has, that matters. The quality of the care she receives there, isn't it?
Yes, and if your lordship, and of course, any child requires safe and attuned care, whether in foster placement or adoptive placement. What was of particular interest in this case was the level of neglect that particularly the youngest had faced, and particularly the level of compensatory relationship she had with her older sibling, which had resulted in particular difficulties there that needed to be managed by the current foster carer. Reference having been made to the older child having undertaken caring roles when they were living with their mother. And as a result, that when they had moved to foster care, there had been a certain degree of difficulty in removing those bonds and developing a more natural sibling bond between the two of them, where the oldest wasn't being forced into a role of undertaking an adult role caring for the younger. And it was even in the evidence presented at the final hearing, the local authority, unfortunately, were not able to provide a great deal of happy news in relation to that, in that that relationship was still requiring a great deal of management from the foster carers. It fluctuated and went up and down. There would be days when they were able to separate them and a more normal sibling relationship would be present, and other days where it would seem to retreat back into the old habits that they'd had when they'd first moved into foster care, and that was a particular concern of the foster carer that was present within the oral evidence presented to the court.
Emma, I'm very sorry. You were about to go on to your second ground and I pulled you back. Forgive me. So
I'm grateful.
Please
Thank you. Turning to ground 2, and this is in relation to the proper consideration that ought to be taken of family members' views. It's been proposed by my learned friend within her skeleton argument at B34 that the local authority has not sufficiently perhaps understood Section 1 of the Adoption and Children Act, and that our suggestions are tantamount to saying that the eldest child's wishes and views and concerns ought not to be taken into account in any welfare analysis. That's not what the local authority is suggesting. What the local authority invite the court to consider is that the arguments raised were that although the eldest child's views were relevant, they were within a mosaic of considerations that needed to be taken into account, and an unfortunate weight was placed upon them. They could not be a determining factor, as I've already outlined, that it could not be simply allowed to happen that the eldest child dictated what happened to the younger by virtue of the fact that she had such an emotional view as to the bond between the two of them, and had expressed such clear views in relation to her fear of the youngest child potentially forgetting their sibling bond. That was a matter for consideration within the eldest child's welfare test in my submission, but potentially of lesser consideration for the younger.
Well, that may be right, but there was plenty of evidence that the judge records that, for example, the younger child's face would light up when her older sister entered the room. So you can't say, can you, that the judge didn't have regard to the impact on the younger child. He says that more than once, I think.
Indeed, Your Lordship, and it's certainly not the local authority's contention that there is no relationship from the youngest child's side in relation to the older. It was acknowledged by the court within the court's own judgment that the relationship from older to younger was of a far greater extent than from younger to older. However, that has to be assessed in my submission, Your Lordships and Ladyship, in the context of the developmental needs of the youngest, and also in light of the compensatory relationship, as it has been referred to, and the difficulties inherent in that relationship. The fact was that the youngest, and it was repeatedly referred to in all evidence and was also present within the final evidence of the social worker. The fact was that the youngest had no relationships with anyone outside their elder sibling, and that was deemed to be of particular concern, as it simply wasn't a healthy reflection of what the needs of this particular child were. This youngest child particularly needed an adult carer who was focused and able to deal with those particular relationship difficulties, and that was why the foster carer had provided such careful evidence to the social worker as to the difficulties and the historical difficulties and how they'd fluctuated over the development of that placement from the very first day in which they were placed in foster carer's care up until the day of final hearing. And certainly those fears had not been displaced. And although it was very clear there was a close sibling relationship, that had to be considered in the round also of that relationship potentially being dysfunctional to a great extent as a result of the parenting that they had received.
Can I just be clear that I understood that submission correctly? As you've reminded us, the judge placed a lot of emphasis, whether rightly or wrongly, I have no view about at the present moment, but he certainly placed a lot of emphasis on what has been referred to as the magnetic point, the sibling relationship. And is it your submission that he seems to have proceeded on the assumption that that was undoubtedly a good thing, but that it may not entirely have been a good thing, actually, because it was not simply a relationship between two siblings. It was of a very particular character, in the sense that I think what you're saying is that the older child was performing the role of parent when she's very young herself. And that wasn't necessarily going to continue if they had sibling contact in the future under the new arrangements that the older child would have. And even if it did continue, I think what you're saying is that it was not necessarily a healthy relationship.
Indeed, Your Lordship has expressed it very clearly. The oral evidence and the evidence of the social worker within the child permanence record and within their final analysis was that the matter came before the court in the context of severe neglect within the parental home. There were repeated references to the children having been left with no food or having to scavenge food from the kitchen, returning to their own room, with the older child providing the younger child with food, the older child providing hygiene and care for the younger child, and given their ages, this was simply unsustainable. And the fact was that when they'd come into foster care, the older child had continued to try and press to continue in that role, and had had to have a great deal of support to backtrack from that role, and was also noted to be intensely concerned even when she was at school as to what was happening with her younger child, with references being made to whether or not the younger child had been left alone. She was evidently in it. Yeah. There was a great deal of concern in that relationship.
Sadly, this isn't the first time by any means I've come across this scenario of a case of extreme neglect, an older child taking over the parental role, so that the relationship becomes extremely complicated. And certainly I can recall other cases where the professionals and the court have decided that the children can't live together because it's bad for both children because of this enmeshed relationship. But of course, that's not the same thing as saying a relationship therefore should be swept away entirely. And that you weren't saying that in this case, obviously. So the fact that it was a difficult relationship does it undermine the fact that it was a very important relationship?
No, and that's not.
And a lifelong relationship.
Indeed, and the lifelong importance of a relationship with one sibling is, of course, of paramount importance. However, nevertheless, the welfare checklist does require a number of factors to be taken into consideration outside of the sibling relationship, and the local authorities' view was that insufficient consideration, insufficient weight had been placed on the very severe severe needs as they viewed them in relation to the younger child. And if the younger child were to be extracted from the dysfunctional elements of the relationship with her older sibling, that would require very focused care from any carer. And it was the view of the local authority that that could not be sustained within a foster placement, where there would be no guarantee either of the continuation of that placement and where the foster carer would not hold parental responsibility. Essentially, the younger child required an advocate that could only be provided via that parental role. Unless I'm able to assist further on that point, Your Lordship.
No, thank you.
Thank you, I'm grateful. In relation to the consideration of importance of that sibling relationship, the local authority submit they'd fully considered the need for sibling contact between these two siblings. They produced not one but two sibling assessments for the court, the first of which recommended that the children remain together, the second of which raised the possibility of separation, but how any difficulties could be mitigated. And the court was invited to infer, this court is invited to infer that when the judge stated that contact was essential, he was referring to those two reports. And a great deal was a great deal of emphasis was pinned on a single reference to the foster carer reporting that she'd seen the youngest child light up when she'd seen a sister, as Your Lordship has already referred to. However, that was also in the context of the child permanence record, where reference was made to the youngest child being locked in her own world, and that there were difficulties within that sibling relationship. And those are particularly considered at A234 at the bottom of the page, A238 at the bottom of the page. My reference to the fact that the younger child was relying on the older in preference to adults is also described there. And reference was made to caregivers needing to be patient, consistent and reliable. And the consideration was that the sibling relationship as it currently stood was placing too unfair a reliance upon the older sibling. The social worker referred in the addendum report at A73 to some evidence of sibling bond. There was therefore a qualification to that statement in relation to the younger child. And it was also clarified that that bond was in the context of neglect and lack of parental availability. And that point was developed in oral evidence, and the fact there was that the mother had been absent and the eldest had assumed the mother relationship with the younger, and that, as Your Lordships have already very clearly pointed out, was not sustainable and potentially damaging to both. And as I've already elucidated, after that initial sibling assessment, there'd been active consideration of separation, and that was what gave rise to the number of assessments undertaken by the court that led to placement in the father's family of the older. And that addendum noted that the youngest would need nurturing support and love, and the inference that this was to be over and above what a developmentally normal child would need given their adverse life experiences, with the report writer referring specifically to the chronic neglect experience, and that impact was only likely to become evident as she grew older. Her developmental needs were therefore already a separate and important consideration, as set out at A74 of the addendum at 6.5. And when considering the youngest in isolation to the older and the impact of separation, the conclusion was that it was almost impossible to know, as her capacity to understand was unknown, and that's again in the addendum at A76, 7.6, and she was described as a child who shut in her own world and happy to play on her own. The social worker pointed out, as I've already indicated, that she did not answer to her own name, and that the eldest whistled to get her attention, and that therefore the logical inference of that report was that any carer would need to grapple with those very difficult issues in relation to the younger.
Could you just give me that page reference again for what you've just mentioned, where it was almost impossible to know the effect of, etc.?
That's at A76, 7.6.
Thank you. this is in the first sibling assessment.
Yeah.
Are you sure about that reference? Did you say 7.6? I may have misheard. You say A76?
Yes.
Did you say 7.6?
Let me just check.
I didn't, with respect, I didn't, that can be.
No,
No.
I
Right,
agree. Was it particularly the reference to capacity to understand?
You said that it would be impossible to know the effect of the separation on the younger child. I'm paraphrasing what you said. But, which buttresses your argument, or the number of your arguments. That's why I just wanted to get the reference right.
There's a reference at A.
Oh, I'm sorry, please forgive me. It may be the last sentence of 7.5 that you're referring to.
I do apologise, Your Lordship.
Her capacity to understand this action is unknown. I'm so sorry.
That's. I'm grateful, Your
Hair
Lordship.
around the bundle. I know how irritating it is when judges do that. Sorry.
Thank you,
Right.
Your Lordship.
A76.
And then in the previous paragraph ends with the observation that although the younger child can't verbalise her wishes and feelings, it's been observed by the foster carer that she lights up when the elder sister enters the room.
Really, then, just drawing this together, this point together, what you're saying, it does come back to the paragraph 8 of the judgment, where the judge speaks in a very striking way about the impact on the older child. And your cases, one of your arguments is that, as it were, distracted him from focusing sufficiently on the impact on the younger child of the inevitable separation.
Indeed, Your Lordship, and it led to an unfortunate result in that the youngest child's welfare and the entire consideration of her welfare became contingent on the older child's wishes.
You accept the fact to take into account, but you say, in this case, he attached too much weight to it. It's there. It's a factor because it's there in the checklist.
Indeed.
As Ms. Gray points out, you accept.
Indeed. But no consideration was given to the other factors that would required careful consideration in relation to the younger, and that's where the lower court fell into error in the local authority's submission. It was also brought to the court's attention in relation to that sibling relationship that the oldest had in fact exhibited resentment towards the younger, and that resentment had come via comments such as stating that life had been better before she'd been born, complaints regarding having to share food, that's at A59 5.13 and A605, and that at the time of final hearing that these two children still required a high degree of support to play with each other, and there was repeated reference to that compensatory relationship that had been forged. Additionally, there was forceful consideration of the local authority as to whether or not it was appropriate for the eldest to be in placement with the father due to the fact that he was expecting a baby, and the consideration was that that might indeed create resentment for the older. So therefore, a global consideration was being given to that sibling relationship and what in fact was at the kernel of it, and whether this was in fact a very deeply held functional relationship, or if in fact a high degree of the reliance placed between younger and older was in fact dysfunctional.
Well, yes, but there is a distinction between what were clearly dysfunctional elements in this relationship. If they'd stayed together, there would have been problems for both of them. But that's not the same as saying that the relationship had no value. ongoing value for the younger child, is it?
No, indeed not.
Nor indeed, would it be wrong for the judge to say, that it was an important relationship? In fact, everybody accepts it was an important relationship.
Indeed, and Your Lordship, that was frontline and centre of the local authorities' cross-examination, submissions, the evidence provided by the social worker in respect of that, and that was why those particular considerations had been fed to the family finder in order that they could provide a statement giving some consideration as to the likelihood of finding an adoptive placement.
So these subtle arguments that you're putting to us about the relationship, that it was important, dysfunctional and important at the same time, you put all that to the judge, and there was lots of evidence about it.
Your Lordship, it was explored extensively because the fact was that it couldn't be avoided given the very clear references made by the older to the prioritisation she placed upon it and the deep importance she placed upon it. So therefore the local authority was required to explore that, particularly given that the care plans before the court were for separation of the siblings, and exactly why and how that could be achievable. And it's the local authority's submission that in fact even before the matter was dealt with at final hearing, that analytical exercise had been carried out by the social workers in this matter in the addendum sibling assessment, given that they'd revisited the potential need for separation of the siblings. It's the local authority's submission that the need for therapeutic care of the younger was simply dismissed by the lower court, who took the view that a foster care would be able to provide that, and it was more likely that a foster care would provide therapeutic care for the younger over and above an adoptive placement.
Which paragraph in the judgment do you rely on when you say that it was dismissed by the judge?
If I may just take a moment to find that within the judgment. It's at paragraph 14A35. And I think this may be a transcript error, because reference is made to the older child. However, it was in the context of reparative parenting for both, and it's stated that the concerns expressed are overstated.
Just what, in which, this is 14, is it?
Yes, paragraph 14.
Sorry, where I'm being slow because I can't
not
see
being
it in paragraph 14.
I'm being slow, I can't see it.
It's the reference to reparative parenting is paragraph 14, fourth line down. It begins the concerns expressed.
But this is the judge reciting the arguments. So the paragraph begins, Faith's father, the elder child's father simply says that the parenting assessment of him is wrong, and then the judge goes on to list the respects in which the father criticises the parenting assessment.
And you, if I may, you say that this is about, in fact, should be about the younger child. But of course, the younger child's father didn't play any part in the proceedings.
No. This was in reference to the older child and additionally the younger, because repeated reference had been made to the need for the younger to be placed singly.
Well, forgive me, the reference, isn't the sentence that begins, the concerns expressed, although it doesn't say so, it is again what the older child's father is saying, isn't it?
Yes, it's potentially of more assistance, and I apologise, Your Lordships, it's my fault entirely, but at paragraph 32, direct reference is made to the younger.
I do think paragraph 14 is about the older child.
I accept
32.
your point, Your Lordship. 32. So it begins.
And adoptive placement is likely to be found for X.
Yes, and then the particular relevant sentence is before turning to that, it is worth stating that although I find the youngest
X,
child is
yes.
developmentally behind, I'm not quite as pessimistic as a social worker.
There is some emphasis in the Guardian's report on the need for reparative parenting in respect of both girls. So I think that's the point you're trying to emphasise
Indeed.
now.
Well, yes. What he goes on to say is that he says he's not quite as pessimistic as the professionals, but even if he's wrong about as a degree of reparative parenting that would be required, he acknowledges what the Guardian says. But if he's wrong about that, he thinks it would be an argument in favour of foster care rather than adoption, and in particular for the younger child to remain where she is.
Your Lordship, in my submission, there's a curious twist in that argument, in that if the younger child were not developmentally behind to the extent pleaded and did not require reparative parenting to the extent pleaded, that would be a further element on the judge's own internal logic in favour of an adoptive placement, because he goes on then to say reparative parenting would be more likely to occur within a foster placement. And so it essentially ends up being an argument that argues both ends to reach the same conclusion.
The difficulty I have, with this line of submission is that what this paragraph 32 may be said to demonstrate is a very experienced judge weighing up lots of factors in actually quite a nuanced and subtle way. So if that's the right way of looking at it, it might be said it's very difficult for this appellate court to interfere with his assessment when there were so many different factors he had to weigh. And of course he had the advantage, as my lord has said, of hearing all of the evidence over many days, which we don't. It's frequently said in this court that all we can do is island hop. We don't see the entire sea of evidence, particularly the oral evidence. So what do you say about that?
In relation to that point, the nuance that was afforded to the argument of reparative parenting, the local authority would suggest that there simply wasn't the evidence base available to that court to come to that conclusion. The court is opining that there will be a foster placement available, that may indeed be the foster placement the youngest is currently situated in, which will provide a level of reparative parenting if required, and that would be over and above what could be found in an adoptive placement, and that it would displace any considerations of the positives in an adoptive placement, such as stability, such as carers who have the parental responsibility, allowing them to advocate for a potentially developmentally delayed child. However, that evidence wasn't before the court. The evidence before the court was that these two children were within the care of a very experienced foster carer, but certainly there was no evidence that she was able to provide therapeutic care. Additionally, there was no evidence before the court, and in fact there was counter evidence before the court that placement could continue. The foster carer had been approached directly prior, and also in the months prior to the final hearing, as to whether she would be willing to provide foster care. She had indicated in the negative. It was only on day 4 of the trial that the foster carer indicated that potentially her view might change and she could provide long-term foster care. The wrinkle was that her age necessitated against her and would mean that she would be unlikely to be approved for long-term foster.
In the event, it's now clear that she can't continue to look after the younger child. So if this appeal is dismissed, the local authority will be looking for, as is probably already looking for, a suitable placement which will, a therapeutic placement, is that right?
Indeed, for the youngest child on her own.
Yes. And that's quite a task. Such placements do exist, but they're not available very easily.
Indeed, indeed. And there had been a difficulty noted, and this was clarified in the oral evidence, that this current foster carer also had 2 other teenage children in placement, which meant that any focus placed on the younger inevitably had to be shared with 3 other children.
So the foster placement we were looking for would be therapeutic, which has a certain meaning, and 1 child alone in the placement.
Indeed, essentially, the ideal scenarios presented to the court by the local authority were either adoptive placement where those therapeutic needs could be met, or, if that were not ordered, a foster care placement where a similar need would be met by a similar provision. And unfortunately, within the judgment, although the learned judge indicates that he accepts the importance of those prevailing conditions, he unfortunately didn't have the evidence before him to simply decide that it would be available within this current foster care placement. And so therefore, the indication given that reparative parenting could be provided in foster placement necessitated inevitably a move of some variety for the younger, despite the fact that within the judgment he had given such weight to the fact that this foster carer was such a good foster carer and could potentially care.
His decision isn't contingent upon the child remaining in this foster placement.
No.
He recognised that she might not be able to.
Therefore, I don't have any further submissions to make in relation to the second ground. I believe they've been covered by the questions asked by your Lordship. I wonder if your Lordship and Ladyship might desire an update in relation to both children and how they're doing, or if that's likely to feature in your decision making.
Yes, we would like to know more about what the current position is. Also, we'd like to know how urgent a decision is on this appeal.
Of course, your Lordship. If I address the urgency point first, the local authority had always acknowledged that it ought to be a time-limited search that was conducted
For adopters.
For adopters.
Yeah.
And they had indicated 6 months. The fact is that the youngest child has already been subject to these orders for approximately 4 months. And so, therefore, time is running ahead, and her age is beginning to marshal against her, although the hope is still within the local authority that a family could be found for an adoptive placement that would meet all of her required needs. In relation to an update, I am told that the oldest has settled well with her father in South Shields. She's not yet in full-time education.
But not saying it too much more about where she is.
No. She has.
Yeah.
She hasn't had any direct contact with her younger sibling, despite the fact that that was given such paramount importance within the judgment, and questions had been asked of the father as to his ability to facilitate that contact. So no direct contact has occurred. I understand some indirect contact has happened over video.
Well, the local authority has the obligation, doesn't it?
Indeed, the
Under
local
Section
authority
34.
has attempted their best. They have provided assistance in relation to schooling for the older child. They've sent a great degree of information over to the father. One particular difficulty was that the preferred care plan of the local authority had been for placement of the eldest with the grandparents, and they have had, I understand, contact with the grandparents who have asked where various documents have been, what help is being provided, advocating on the father's behalf. The difficulty is that the father has been provided with that assistance but simply hasn't taken it up. So therefore that information has also been forwarded to the grandparents in the hope that they can assist from there.
I mean, the ball is in the local authority. If this order stands, the ball will be in the local authority's court to arrange contact. And if the older child's father doesn't cooperate or doesn't make satisfactory arrangements, then I suppose you'd have to go to court. It's quite an unusual situation.
It would be an intensely unusual situation.
But that's what you have to do, isn't it? You have to go and ask for. I'm not sure whether it was Section 8 or Section 34. Think about that.
Yes.
Anyway, an order for contact.
Indeed, and that was a consideration given at court, but wasn't pursued. But yes, the consideration of the local authority was that some form of contact order would be needed. It's sadly not been the case that contact has happened on the basis that the judge had hoped for.
No.
I understand.
Well, I do say that it's not all the fault of the older child. The local authority has a statutory obligation.
Indeed, Your Lordship, and that is of course acknowledged. And the local authority will continue to make strenuous inquiries and provide all the assistance that they can, and if need be, return the matter to court if that means that that's the only way of enforcing such contact as happening. They have developed good relationships with the grandparents, I understand, so that would potentially mean that avenue could be used prior to any application to court.
Yes, and I'm sorry, I'm being a bit persistent about this. It is the local authority's responsibility, and the senior managers, team managers need to know this, and so does the senior management within the local authority.
Of course not.
And it needs to be a subject. It needs to be. It would need to be at the focus of the 6 monthly reviews, which the younger child will be under. The guardian will be off the scene by this point, so it really is important.
Yes, Your Lordship is of course paramount. So I'll make sure that all of those comments are passed back to
Can I
individuals.
go back to the first point, the point about urgency? If this child is to be adopted, if this appeal to be allowed, you need to know that as quickly as possible, so you can get on with the search. She's rising 3, isn't she?
Indeed. That's indeed the point that I was attempting to make, Your Lordship.
Thank you.
In relation to the youngest and an update in relation to her welfare, I understand actually that she managed the move of her older sibling away from the foster placement very well, and in fact very limited evidence of any difficulty. However, I acknowledge that that's in the context of her not necessarily having had the capacity to understand, as I've already outlined. I am told that she has begun to develop some language, albeit late, with some words beginning to appear.
Is she having speech therapy?
If I may just turn my back. Yes, I'm able to confirm that the preschool were looking into it, so I don't know if it's yet commenced, but that was certainly something that was being considered. She has developed a good relationship, I am told, with the foster carer, her current foster carer, but that placement can no longer continue. They are searching actively for other placements in which she can be situated. And I'm also told that she's still very reliant upon sign language to communicate her wishes, needs and feelings. That the virtual contact has gone okay, but nevertheless the problem is, given her age, and it would be of difficulty for any child of that age, but particularly a child with these developmental needs, it has not necessarily been easy contact to facilitate.
Is the older child having contact with her mother?
If I may just check on that, Your Lordship. My understanding is it's been virtual. The mother is in a mother and baby placement, I understand, in Birmingham, so therefore any contact has to take place over video link.
The there are proceedings about the younger child, the new baby.
Yes, indeed.
There are.
Indeed.
Thank you.
Unless I'm able to assist further on any particular point.
Very helpful. Thank you very much.
Thank you. I'm very grateful, Your Lordship.
Yes. Were you going next?
I had anticipated going last.
No, that's fine. Yeah. Yes. That's great.
I hope that you can hear me, my lord. I'm somewhat vocally challenged, I'm afraid, today. But do my best. My lord and my lords and my lady, the mother's case is that the judge conducted a side-by-side analysis of adoption and long-term fostering that was detailed and highly individualised. He placed significant weight on the issue of sibling contact, but he did so because of the evidence that he had seen and heard. And he was entitled, in light of that evidence, for the reasons which he gave, to conclude that this was not a case in which adoption was necessary, as he said, far from it. If I may deal with ground one first and then turn to dealing with ground two. I rely on four specific reasons, why the judge's decision should be upheld in relation to ground one. Firstly, that the judge was not wrong to place significant weight on sibling contact. Secondly, that the judge gave his reasons for departing from the views of professionals and that they were cogent and clear. Thirdly, that in conducting his own balancing exercise, the judge engaged with the key differences between adoption and long-term foster care identified in the case of Reeve. And fourthly, that the judge conducted, in addition to engaging with the factors identified in the case of Reeve, the judge conducted an individualised side-by-side balancing exercise of the two options in light of his welfare analysis. Turning to the first of those factors, in my submission, the judge was right to note at paragraph 37, page 84, A41 of his judgment, that separation would be particularly significant for the older child, and that the loss for the younger sibling would be less acute. Nevertheless, was the unanimous professional evidence that the children had a close and affectionate relationship. In fact, so close, and this is the very important context for this case, that it was the recommendation in the first sibling assessment that it would have been detrimental for them to be separated at all, and that adoption would have been traumatic for the younger child. And your Lordship can find the reference for that at A76 in the bundle. And the judge noted at A33 that the younger child relied on her relationship with the older child. And he also noted that she lighted up when she saw her sister. It was clear that he was impressed by the closeness and affection that he had heard and seen from the witnesses who had appeared before him. In the course of Miss Gould's submissions to your Lordship this morning, it was suggested that the court had heard about a dysfunctional relationship between the two girls. I have sought somewhat in vain to find references to this in the papers that were before the trial judge. There is some reference to this in the social worker's final evidence, which the court can find at A229. In my submission, there's a detailed analysis here of the positive aspects of the relationship between the sibling relationship and also the negative aspects of the sibling relationships.
Are you to A229?
A228 to A229.
Yes, the positives and negatives.
Positives and negatives of the sibling relationship, and this is the final evidence of the social worker social worker.
When you say you've searched in vain, the word dysfunctional, is that what you're...
Yes. Yes. What I mean by that is, it was being suggested by Ms. Gold that featuring heavily in the local authorities and the professional analysis was a real concern about the children's relationship with one another, and that this was factoring in their analysis, both as I understood it, in terms of the need for the children to be separated from one another, because of course that wasn't the initial recommendation of the local authority. The initial recommendation was that the children should be kept together in May. And secondly, in terms of the local authority's position in terms of contact, their position in terms of contact being that the arrangements under adoption would be sufficient for the younger child's needs. And what I mean
so we have the positive factors,
yes,
228,
and A229,
and the negative, and you say the way it was put in the evidence is specifically in the 4 bullet points at 229 under negative.
It appears so.
So is this your point that it's not, that it's been somewhat overstated? Is that what you're saying?
It appears so.
Today.
I acknowledge that listed here amongst the factors, we have
observed to have adopted a caring role.
Yes. And notably that it had been relinquished and had re-emerged.
Yes.
And there then appear to be a number of other negative aspects of the sibling relationships, none of which relate to this dysfunctionality. Then crucially, I invite the court to look at another, even more important document. And this important document is the addendum sibling assessment, which your lordships will find and your ladyship will find at A253. Begins at A253 in the passage. I'm going to take you to a number of passages in this document. But the importance of this document is that it is the definitive statement by the local authority of their analysis of the children's needs as siblings and their rationale for proposing at this point in time placement apart and what their ongoing contact needs are. And in this document, you find no reference to the dysfunctionality of their relationship. And what you find are the following passages, which I'm going to take the court to in turn, which I say are important. Paragraph 4.1 at A255. The children have never lived apart. The elder child has been in the younger child's life every day of her life, either whilst living in the family home or in their foster placement. To separate the children is likely to be both upsetting and confusing for both of the children. Paragraph 4.3, both children will experience a sense of loss for which they will need to grieve. Paragraph 5.1, they've lived every day of the younger child's life together, and the separation is likely to create a great deal of distress for both children. Paragraph 6.1, A256, both children are likely to experience the separation as a loss. And finally, conclusion, A256, again, no note of any dysfunction in the children's relationship with one another. It is recognised that the separation of the children is likely to be both upsetting and distressing to both children.
So, nothing here about, to repeat what the positives and negatives that we've seen in the earlier doc.
Yes.
That
The point I'm making simply here, my lord, is that when I say that the judge isn't wrong to place significant weight on the sibling contact, I simply say that the unanimous evidence that the judge was relying on when he places significant weight on this factor is the evidence of the children's close, affectionate relationship and of the significant impact that separation would have on them, and more than that, of the essential need for them to have ongoing contact with them. And I invite the court to treat with a significant degree of caution any suggestion that there was a level of dysfunction in that relationship, because I say that it's simply not borne out, in particular in this definitive statement of the children's relationship that one finds here in this sibling assessment. Secondly, I submit that the judge wasn't departing from the views of professionals when he attributed to the sibling relationship significant weight, because professionals were attributing to the sibling relationship themselves significant weight. It was the recommendation of the social worker and the guardian in their written evidence. You can see this at A256 and A275, and also in their oral evidence that it was essential that ongoing sibling contact was maintained. And it clearly made a significant impression on the judge, because he notes it at numerous points in his judgment. A33, paragraph 9, A35, paragraph 13, A39, paragraph 32, and A40, paragraph 33.
Sorry, just the paragraph numbers again. 9.
Paragraph 9, paragraph 13, paragraph 32, and paragraph 33.
Thank you.
Finally, given the evidence the judge had seen and heard, he was entitled to attach significant weight to this factor. And I invite the court to contrast this case to the case of Re-V, which your lordships have in the bundle. The citation is 2013 EWCA CF 913, and it appears at A123. And in that case, which I pause to note, does not concern sibling contact, but rather the children's contact with their mother. A central feature in the Court of Appeal upholding the appeal was that they were satisfied that in conducting his balancing exercise, the judge had either failed to recollect or failed to give weight to the significantly detrimental features of the mother's contact with her children. And your lordships can find that in paragraph 91, A142 of the judgment of the Court of Appeal.
Sorry, which paragraph?
Paragraph 91. And that feature, for the reasons which I have given already, does not in my submission apply here. Here, the judge was entitled to place significant weight on this factor based on the evidence that he had seen and heard.
Did the judge in this case consider that the sibling relationship was 100% a good thing? Did he recognise that there were any negative features to that relationship at all?
He doesn't appear to comment on the dysfunctionality of the relationship, which is.
Well, let's not necessarily use the word dysfunctionality. But does the judge regard the sibling relationship as having any negative aspect? at all.
His observations about the sibling relationship can be found at A33, para 7. They are mixed. He says there is a sense that the younger child has relied on her relationship with the older child, and that's picking up on the passage, arguably, that I've just taken the court to in the social worker's final evidence. And he also describes further down towards just above paragraph 8 over the page. He picks up on the younger child's development, noting that she was understimulated by her mother but not by her older sister.
Yeah.
And those are his observations about the.
So the negative side, if negative's not quite the right word, but if we're looking for something which isn't entirely positive,
Yes.
it's the fact that the older child's adopted the role of carer, so that the younger child has relied on that relationship. Possibly one could infer a negative or disadvantage in that. Not spelt out though, is it?
If you perceive that as a negative, there's also a passage where, I think it's paragraph 37, where he contrasts the difference between for the two children in terms of how they will feel the loss. It's arguably a slightly different point.
But this is where the difficulty may lie, you see. Living in the real world, that if the nature and quality of the relationship has not been the conventional one of two siblings, but at least to some extent, it seems, has been one in which the younger child has relied upon the older one, who herself is very young, to take the place of her mother. Well, first of all, two questions potentially arise. As a matter of common sense, I would suggest. One, is that a healthy relationship? Two, if sibling contact is going to continue in the future, is it going to be of the same nature and quality? I would have thought not, because what you're hoping to achieve, ultimately, in the interest of both children, it is not that quasi-parental relationship. Or am I looking at it the wrong way?
Well, this in my submission, is precisely whether this court has to be very cautious. It seems to me that the evidence that the judge heard was that the relationship between the siblings was a very positive one, and one that all of the professionals appeared to have been very clear to him was one that needed to be preserved and to be maintained, and that they identified was essential. And aside from a passing reference to the elder child wanting to take on a caring role that appeared to have been addressed and had only briefly re-emerged, this doesn't appear to have been a factor that the professionals were placing great weight on. So one can quite see that there might be another case in which the factor that your lordship is identifying would be a significant one, and would be one that professionals would be very wary of, and one which would cause a judge to want to make a different order for the younger child, because the judge would consider that sibling contact was not for this child essential to maintain, because there were real concerns about its impact, and actually it was more important to have the permanence and stability of adoption. That was not this case, and that's why this court has to be so cautious about not interfering with the judge of the lower court having heard all of that evidence. And I would again remind the court of this really important passage of the judgment where he deals with the evidence that he heard about all of these matters, and he refers to the cross-examination by Mother's Counsel. It's A40, paragraph 32. This was clearly a part of the evidence that really he was really struck by. And he says, Mother's Counsel, armed with the mother's history and the need to keep the children together if possible, was robust in her cross-examination. Why is it thought that if the foster care is so bad in comparison if adoption means losing your sister? And if it has worked so well to date? To these, I would respectfully add, and comparative care is needed. I record there were no persuasive answers to these questions. And what I would add, Lord, I would remind the court of the famous passage that from Lord Hoffman, it's quoted by Lord Wilson in Re B, and the court can find it at A19 in the authorities bundle, where Lord Hoffman says that the court's expressed findings are always surrounded by a penumbra of imprecision as to emphasis, relative weight, minor qualification, and nuance, of which time and language do not permit exact expression, which may play an important part in the judge's overall evaluation.
And Lord Wilson commenting about it in paragraph 42,
Yes.
developing it.
There are, analytically, there are actually two different kinds of questions that can arise. One is the purely factual question or even evaluation of those facts, which Lord Hoffman is referring to in Piglovska, and also what he had said earlier in the Biogen case. And this court is very familiar with that principle. Right across the board, it arises in many different contexts, not only in family cases. But there's a different point, which I think is what Re B is about, which is proportionality. And there's a lot of learning now, including in many decisions of the Supreme Court, about whether an assessment of proportionality is to be treated in exactly the same way as questions of fact. And actually, the learning of, as I understand Re B, and it's been confirmed in more recent decisions of the Supreme Court, ultimately the question for the appellate court is whether the first instance decision is wrong. And that's not necessarily the same sort of question as the way we deal with, for example, questions of fact or even evaluation of facts. Because if you test it this way, if it goes the other way, suppose there's an adoption or a placement order made, and you wish to argue on appeal that that was the wrong outcome, and the balance is just wrong. In principle, you can do that, can't you? and an appellate court can take a different view from the first instance court, being cautious, of course.
In answer to your question, my lord, I invite you to look at paragraph 51 of in the matter of HW, which
51 HW.
yes,
Yeah.
you have at A1, begins at A107.
So this is at tab 3.
Follows the passage which at 40, if you perhaps look first at 47, so it's clear why I'm taking you to 51. So at paragraph 47, the Dame Siobhan Keegan sets out the passages which appear in my skeleton argument and drawn from RBS and in RG, dealing with the what is meant by the balancing exercise which the judge was undertaking in this case. And at paragraph 51, the court says that on this appeal, and I would suggest that the case in our case, the court is concerned with the same issue, that the issue that the appellate court was looking at was not whether the conclusion that the judge had reached was wrong, but rather whether the question was whether the adequacy of the judge's process of reasoning
I may be misreading it, and you may say that I am misreading it, but I think there Dame Siobhan Keegan is simply identifying what the real issue was in that particular case. There's nothing inconsistent, as I read her judgment, between that passage and what she said earlier at paragraph 49. Paragraph 49, as it appears to me, is the passage which summarises what the Supreme Court has said now in a number of cases. The appellate's court function is, as explained in Re B, to review his findings and to intervene only if it takes the view that he was wrong. So what is being emphasised, and was emphasised in Re B itself, is that, of course, the appellate court is not a court of first instance. It's not simply rehearing the case.
Yes.
Its appeal is conducted by way of review.
Yes.
That's the emphasis on the word review. But then she goes on to say, in conducting that review, an appellate court will have clearly in mind the advantages that the judge has over any subsequent court. See Lord Wilson in Re B, that's the passage you've shown us, and the early decision of the House of Lords in Piglovska, again, a case you've shown us by indirect means. So as I read it, there's nothing in Re HW which is any kind of radical departure from the previous decisions of the Supreme Court.
No, and forgive me.
On the contrary, it actually summarises in paragraph.
No.
Dave Siobhan summarises in paragraph 49
Yes.
the ratio.
Right.
Is that the right wrong word? The approved principle in Re B rather more succinctly than respect they did in Re B itself.
I quite agree. The point I was trying to make was that the focus of the court is not on the outcome or the conclusion, but the process of reasoning. And it's only if this court is satisfied with the process of reasoning that the judge conducted the balancing exercise, that the judge made a mistake in conducting his, that the judge's process of reasoning in terms of how he conducted his balancing exercise was wrong, that the court can interfere with his conclusion.
All right, I understand the submission. Where are we going next?
I've to a large extent covered the second argument that I was, the submission that I was seeking to develop, which was that the judge gave his reasons starting from the views of professionals which were cogent and clear. But I'll deal with it at some speed if I may. But my submission in brief is that where the judge departed from the views of professionals was in his assessment that adoption couldn't support the younger child's needs for ongoing contact, as identified as essential by the professionals. It's nevertheless clear from his judgment that he did give their views anxious consideration. He describes in his judgment that this was as nuanced a case as any that he had considered. That's at A34, paragraph 12. But he had clearly found himself unconvinced by their arguments, and I've already taken the court to the passage where he describes the evidence that he heard from the cross-examination by Mother's Counsel, A40, paragraph 32. It is clear that the judge felt, in light of that evidence, that there was something missing from the professional's analysis of the case, without making any criticisms of them. He took the view that the professionals having assessed that this was a child for whom ongoing contact was essential, and for whom foster care had worked so well to date, and for whom reparative care was needed, he was unpersuaded by their evidence that adoption was the right outcome, and more than that, he was unpersuaded that it was necessary. Turning then to the third reason why I say that the court should uphold the judgment in relation to ground one, that in conducting his own balancing exercise, the judge engaged with the key differences between adoption and long-term foster care as identified in the case of Re-V. The court confined Re-V at
Tab 4.
Yes, and the key passages I'm inviting the court to look at are A144.
I'm afraid the page numbers have fallen off. What's the paragraph number?
95 to 96. I should begin by noting that Lady Justice Black, she then states that paragraph 95, before identifying some of the key differences between long-term fostering and adoption, that nothing that she says in paragraph 96 is intended as a comprehensive comparison of the two arrangements or as a substitute for professional advice to the court. And with that caveat, she makes the following observations. And it's my submission that if we look at the key differences that she highlights in that judgment, we see that the key differences that she deals with there are all addressed by the judge in his judgment in this case. Taking them in turn. At A41, paragraph 36 of the judgment, the judge acknowledged that adoption was likely to provide the younger child with a forever family in a way that long-term fostering would not. And there was therefore an explicit acknowledgement in the judgment of the permanency and security afforded by adoption. And he also repeatedly acknowledged that long-term foster care carried with it the prospect of moves in the future, frequent or otherwise. The court can find those references at A39, paragraph 31, A42, paragraph 42. Turning to the second factor, A40, paragraph 34 of the judgment. The judge referred to the possible discharge, the care order, the future.
In 34?
Yes. The third factor relates to contact in the adoption context. It goes without saying in the submissions that the court has already heard and will hear further from me further in due course, that there was significant consideration in the judgment of the differences between the arrangements for contact under the two regimes. And finally, the judgment acknowledges that routine life would be different for an adopted child compared to a child in long-term foster care. At A39, paragraph 31, the judge states that if the younger child remained in long-term foster care, she would be subject to continuing professional involvement and the prospect of moves in the future, frequent or otherwise. And I also invite the court to refer to page 42, paragraph 42.
Can I ask you for your help on something I asked Schooled as well? This may be one way of looking at the judgment, but please correct me if it's wrong. The judge appears to be saying that there are aspects in which adoption would be better than long-term fostering. But do I find somewhere in his judgment the judge expressly addressing the consideration that long-term fostering may have detrimental consequences
Yes.
on a child?
Yes. Would you like me to take each of those
Please.
examples? At A41, paragraph 36, my lord touched on this example earlier.
Yeah.
The judge acknowledged, I mean, I say that because of the nature of the side-by-side analysis, I should preface this by saying because of the nature of the side-by-side analysis that the judge was conducting, the inextricably linked the positives of the negatives of long-term fostering and the positives of adoption are inextricably linked. So, but in any case, what follows are some examples. A41, paragraph 36. The judge acknowledged that adoption was likely to provide Matilda with a forever family in a way that long-term fostering would not. He goes on to
But just
repeatedly...
before, I'm so sorry, just before we leave that paragraph, he also refers to the wall of photographs of past foster children. Is that a reference to the links which past foster children have maintained with the foster carers?
Yes.
I mean, a lot of foster carers do in practice keep relationships going with children, but it doesn't, I mean, it's generally perceived that, well, as he puts it, adoption is likely to provide a forever family in a way that fostering.
He's nevertheless acknowledging in my submission that it's not going to provide her with a forever family, although there are cases in which long-term fostering can provide a long-term placement, not a forever family for some children. That's my understanding of what he's saying in that paragraph.
Or if not a forever family, then a lasting relationship of some kind.
Yes, that's my understanding of what he's saying, precisely. He goes on to say that long-term foster care carries with it the prospect of moves in the future, frequent or otherwise. A39, paragraph 31, and he makes the same point at A42, paragraph 42. And at A39, paragraph 31, notes that if Matilda remains in long-term foster care, I'm so sorry, he notes that if the younger child remains in long-term foster care, she would be subject to continuing professional involvement and the prospect of moves in the future, frequent or otherwise.
Strictly speaking, what he's talking about at 42, he's talking about the older child, isn't he?
But nevertheless, I think you would say that when you read the judgment as a whole, the judge clearly had these sorts of considerations in his mind.
Yes.
And do you place reliance on the first sentence of paragraph 47? That this wasn't an abstract exercise, as I understand it. Ultimately, there are two options for the younger child. It comes down to adoption or long-term fostering.
Yes.
And he comes to the conclusion that long-term fostering is the better option.
Yes.
And he explains why. So your submission is that there it is. He's done the side-by-side analysis of the two options required by REV. And he's explained why he's come to the view he has. Whether the local authority agree with that conclusion or not is neither here nor there.
Exactly. And I say that his when he looks at each of these factors, he may not give them the most detailed consideration, but that's because what he is carrying out is, in my submission, a highly individualised analysis for this particular child, and he is identifying the particular factors which weigh most pressingly and which have the most to which he attaches the most weight, bearing in mind the evidence that he had heard. He attributes them the weight which they deserve. I don't say that he doesn't treat them dismissively. He deals with them appropriately, but certainly not dismissively. And he then goes on to deal with, in far greater detail, but not excessive detail, the factors that he identifies as being of particular importance for this particular child in this particular case. And that brings me to the final point in my submissions on this ground, which is that the judge had conducted highly detailed and individualised side-by-side balancing exercise of the two options in light of his welfare analysis and the evidence that he had heard. Firstly, aside from sibling contact, the judge noted a number of particular features in this case that were deserving of particular consideration. These included the prospect, and he doesn't put it any higher than that the younger child could remain in her current placement long term, which he said deserved further exploration, A39, paragraph 31. And he also noted the factor of developmental delay on which the local authority placed such weight. He observed that if the younger child needed some level of comparative parenting, that was a factor for him, an argument rather for him, which went in favour of long-term foster care more so than adoption. A39, paragraph 32. He carefully balanced each of these factors into his side-by-side analysis of each of the two options. Further, having determined that sibling contact was a feature which deserved particular weight, he carefully scrutinised the two options for the younger child in light of this. And he identified two particular reasons why he didn't consider that adoption could sustain the sort of arrangement for sibling contact that he had identified as essential in light of the evidence. In my submission, they were clear, cogent. The court should not interfere with them. First reason was the uncertainty of identifying a placement for a child where sibling contact had to be maintained, as had been identified in general terms in the statement of the family finder, which the court has at A239, which the court has at A239, beginning at A239, and that the court had also heard in oral evidence from the professional witnesses. And it appears to be accepted that the evidence that the court heard was to the effect that sibling contact between the girls would in itself narrow the pool of available adopters, and that the fact that the older child was having contact with her mother would further narrow the pool of available adopters. The court was entitled in light of that evidence to express himself to be unsure that a placement could be found for the child, an adopted placement could be found for the younger child. That was the first reason which he gave for being unsatisfied, and that he could that adoption could sustain the sort of arrangement that had been identified as being essential. The second issue he identified was that even if it was achievable, sibling contact would be a far cry from the kind of arrangements which would be possible from foster care. And he talked about evidence at the hearing of up to 4 meetings a year, video link, contact, short encounters. This is at A40, paragraph 33 of the judgment. And his view was that a much more creative, flexible and broader approach to the younger child's time with her sister was possible and desirable in this case.
What do you say to the point which really emerges from Miss Gould's description of recent events? What do you say to the point that the judge had an over-optimistic view of what could be achieved in any event if the child remains, if the younger child remains in foster care, because of the difficulties arising out of the older child's placement, that she is 200 miles away and with her father. What the judge was saying in paragraph 47, I can see no reason why they shouldn't be holidays spent together and other regular meetings. Well, was he over optimistic in that respect?
2 points. Firstly, he was entitled to form the view that he did based on the evidence that he had heard. He heard evidence during the trial that the older child's family had expressed a willingness to facilitate contact, particularly holiday contact. It's worth noting that, in fact, although direct contact hasn't taken place yet, my understanding is that it is due to take place during the Easter holidays. So he's not entirely wrong about that. In the sense that holiday contact will be happening. The second point that I wish to make is the point that your lordship has already made in the exchange that you had earlier with the local authority, that insofar as direct contact has not taken place in the manner in which the judge was clear that it should be happening, that is a failure, and it ought to be happening and being supported to a far greater extent than it has been already. Local authority ought to be doing its utmost to ensure, in accordance with its statutory obligations, more is being done to support the siblings' relationship. Returning then to my submissions.
Your fourth point was that he did carry out the side-by-side analysis.
Yes, thank you very much, my lord.
Which you sort of covered already.
Yes.
It wasn't as side-by-side as some analysis I've seen, if I can put it like that. He doesn't draw it all together by saying, on the one hand, the concluding paragraph saying A, B, C, D, E, on the other hand, X, Y, Z, does he? You say that doesn't matter.
My lord, I submit that he carries out. I would defend the judge from that charge. I submit that actually what one has from. I mean, he first of all he has a extremely I would firstly remind the court that this was an extremely complex balancing exercise, no less than 7 options that the judge is considering, and for two children, and what he and it's an extremely, in my submission, sophisticated and detailed analysis of both children's needs, identifying from paragraphs 39 onwards in some detail what the precise, having already identified at the outset what the options are. It's the judge also identifying what those options are. The options that he sets out are not, in fact, reflected have not been identified for him by the local authority. I don't mean that as a criticism, but it's a reflection of quite a careful analysis already by him that he identifies as many options as he does. He then, from paragraphs 39 on, conducts his analysis for both children and then draws it together at paragraph 47 really is the conclusion that we have for Matilda.
And then at 49, he says there's no perfect solution. Each option has significant disadvantages. And then he goes on to say that having decided the preferable option for each child individually, he's revisited his conclusions.
Yes.
So that is quite sophisticated, at least seems to me to be quite sophisticated.
Thank you.
Well, that's complying with what Justice McFarlane said should happen in REG.
Well, displaying my ignorance.
My lady's right. He cross-checked it. Cross-checked.
In the course of Miss Gould's submissions, she suggested that the judge was wrong to conclude that the level of contact would be meaningfully different as between the two arrangements in terms of long-term foster care and adoption. I would ask the court I would remind the court here of the passage that we looked at the start of my submissions in this area. In 3V, paragraph 96, where Lady Justice Black, as she then was, looks at contact in holistic features. And she specifically observes that there are the differences. She specifically observes that there are differences between the two arrangements. She says there towards the end of Roman 3, paragraph 96, towards the end of Roman 3, that the situation still contrasts markedly with that of an adopted child, or open adoptions where the child sees his or her natural parents, but I think it would be fair to say that such arrangements are not to be seen if the adopted parents are not in full agreement. Once the adoption order has been made, the natural parents usually need leave before they can apply for contact. And in my submission, the judge's the views expressed by the judge on the subject of the differences between contact and long-term foster care are entirely consistent with the judgment of Reevy with the case of Reevy. He was right to determine that there are meaningful differences between those two arrangements. Finally, it is clear that he considered a number of different permutations what he refers to as option 6 and option 7. He doesn't look at them as in detail. He had no need to. He describes them only as variations to option 5, and they were not being pursued by any party in any event. And the mere identification of those options in my submission shows that he was engaging in a careful process of analysis as to whether adoption could be whether adoption could be the right outcome for the younger child. Ultimately, he concluded that he was unable to say that nothing else will do other than a placement order, and the respondent submits that the judge was entitled to reach that conclusion, having gone through the rigorous exercise that I have described above. If I turn now to ground 2, the first respondent submits that the court should uphold the decision of the judge for 3 reasons: that the judge was entitled to have regard to the views of the younger child's sibling, that the views of her elder sibling did not dictate the welfare outcome, and that the judge revisited his conclusions in respect of each of the children in light of his conclusions for the other. It appears that it's now common ground between the local authority and the first respondent. Not only was the court's paramount consideration the younger child's welfare, but also that the court was entitled to consider the wishes and feelings, not only entitled but must consider the wishes and feelings of any of the child's relatives. That would, of course, include the younger child's older sibling, and therefore that it was appropriate for the younger child's older siblings' wishes and feelings to feature, and I don't understand there to be any difference of opinion between us in relation to that point. The issue between us is whether the elder siblings' wishes and feelings dictated to any extent the outcome or predominated in the judge's assessment of assessment either of the welfare analysis or in the balancing exercise. And to a large extent, the submissions that the mother relies upon regarding the highly individual balancing exercise, which I suggest that the judge undertook in this case, apply equally under this heading. I submit that it's very clear reading the judgment that the judge was conducting full analysis, looking at highly specific factors relating to Matilda. I've already pointed to a range of factors that were specific to the younger child, including the prospect of her remaining with her current foster carer, her developmental delay, and the sibling contact looked at specifically through the lens of her own experience with her older sibling. It's my submission that the evidence that the court had regarding the sibling relationship was not one-sided, and Lordship pointed out during the course of Ms. Gould's submissions that the judge reminds himself of that at paragraph 9 of the judgment. Reminding himself of the guardian's words and evidence. Crucially, in this particular case, I also say that the 2 sibling assessments and the important context which they play in this case. So, as I've already observed, it's notable that the initial recommendation was for the children to be kept together, that adoption would be traumatic for the younger child, and the judge's important observations about the closeness of that relationship from Matilda's side, which the court can find at A33, paragraph 7. Finally, and your ladyship has picked up on this point a few moments ago, the judge, I'm sorry, am I louder?
No, it's all right, don't.
If I
Yeah,
pause
understandably,
to
your
have
voice has slightly dropped. You've done very well.
I'll pause to have some water if I may. So sorry. Finally. Your ladyship picked up on this this point a few moments ago. If, in my submission, if the reader was in any doubt about the judge's focus in his judgment, that concern can be put to one side by A44, paragraph 49 of his judgment, in which the judge records that he revisited his conclusions of each child in light of his conclusions for the other. And he asks himself, if the older child is to leave the current placement, might that not favour adoption for the younger child? I do not believe so. I suggest that by revisiting his conclusions in this way, the judge shows that he was taking care to avoid falling into error in the way that the local authority expressed, and he was ensuring that he conducted an analysis in which his conclusions in respect of one of the children did not inform welfare planning of the other. Unless I can be of any further assistance.
Yeah, that's been very helpful, thank you. Yes. If it's convenient, then we will adjourn until 2.
All right.